lives here. Folks, I'm sorry. Now sitting at Boston, present and for the Commonwealth. QUADIR, give your attendance and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning, everybody. Welcome to the Appeals Court session for Friday, May 12, 2023. I'm Justice Greg Massing. To my right is Justice Joseph Ditkoff. To my left is Justice Sabita Singh. We will be your panel for today. We have two cases on the schedule, and I think the parties were not all here for the first case, so we're hearing the second case first. We have read the materials, so we're prepared. You can go right into your arguments. Each side gets 15 minutes. There's no rebuttal in the Appeals Court or the SJC. And we all have your materials on these tablets here, so if you see us looking at our devices, we're actually looking at case materials. We're not looking at the sports from last night or anything like that. And with that, I'll call this case our second case, which is MORIARTY versus QUADIR. You can maybe help me with that. 22P931.
May I proceed?
Yes, please.
Good morning, Your Honors. If it so pleases the Court, my name is Mark Lanza. I'm the attorney for the plaintiffs' appellants, who I'll refer to as the appellants. The glaring issue in this case is it involves the right of the dominant estate holder to make changes or modifications to an easement without the consent of according to the land court, no consent of the serving estate holder is required, and really places no limitations on the changes that could be made to a realignment or a widening of the easement, and doesn't require, as in the MPM case for a serving estate holder, doesn't require, in the case of a disagreement, a declaratory relief action.
So you're focusing on the placement of the hairpin driveway, right, and the expansion or narrowing of it. At the moment, you're not focusing on whether there's an easement to reach Lot 3B or Lot 10E or whatever you call it.
No, I will get to that.
Okay.
But
just want to.
But that's really the key issue in this case. I mean, in the MPM case, we have MPM versus Dwyer, the SJC, dealing with the right of the serving estate holder to modify the easement without the consent of the dominant estate holder, had footnote 4. Now, I want to quote from footnote 4. We previously have concluded that the dominant estate owner, that is the easement holder, may not unilaterally relocate an easement. And there's a case cited, Kessler versus Bowditch. That's precisely what the land court judge did in this case. He determined that the dominant estate holder could unilaterally change the location of the easement without the consent of the serving estate holder and without a declaratory relief action by widening it and or by realigning it. Okay? We take no issue with the other things that the judge ruled the dominant estate holder could do to the easement, grade it, fill potholes, pave it, maintain it, remove limbs, all that sort of thing, all within the four corners of the easement, that is the borderline of the easement. But to say that the dominant estate holder can enter on the serving estate holder's property without consent, without any agreement, and without the need for a declaratory judgment from a court of the Commonwealth in the event of a disagreement is unprecedented in the state. It is bad law, and it needs to be clarified and reversed. And that's why we're here.
So did I hear you correctly? You're saying that is the only issue that you're really challenging, that you have no issue with any of the other judges' findings or conclusions? No,
we have an issue with the finding of implied easement on summary judgment. We take issue with his finding that there would not be an overburdening or overloading of the easement by allowing it to be used for access to another house off the easement. And we also really take issue with his finding that there was an interference, a substantial interference with the easement by the plaintiffs and appellants. But the key legal issue is the one I just cited, the one I just described. The judge also found that there was an implied easement created in 1968, essentially in the same location as the 1958 express grant of easement. And again, the law of implied easements essentially, in some, is that, an implied easement arises when there is no easement in place, no express easement in place, based on the intent and the actions of the parties. Well, in 1968, when Lot 3B, the lot that at issue at that point in time, was created and conveyed, to, it's now owned by the people who own the appellees, conveyed to their predecessors, the 58 easement was in place. Its boundaries were clear. It's shown on a record plan, recorded at the Registry of Deeds. There was no question about its location. So why would there be a need? How could a implied easement arise? Why would there be a need for one when there was one in place that provided undisputed access to the lot that was being created by a land division? I mean, we have a record, on record, an express grant of easement that says, the owner of lots B1 and B2 from which all this land is derived.
Well, you can't have it both ways.
Exactly.
If that written easement grants access to Lot 3B, then it can't possibly overburden it to have access to Lot 3B.
Well, access for what? I mean, that's really what it comes down to, okay? Access, to get there, to drive there, or access to build a house there and use a house there, okay? We have to go back to what was on the minds of the parties in 1958 when the easement was created. And in 1958, anything, the land which is at issue here, okay, which is really 9 Bushnell Drive, there was a single house there. So the easement was granted for the owners of Lot B1 and B2, and B2 is essentially 9 Bushnell Drive, the land that's being accessed, the appellee's land. There was a house there. So
Why is an easement for access, why would that define what you can do once you get to the other property? I mean, the purpose of the easement is access.
Correct.
Why would there need to be, why would that easement define what you can do on the property?
It would be access for what? Access for a 10-lot subdivision, access for one single-family house?
No, but that is the answer. It's purely access, not access for a purpose, but just access between one place and the other.
And we don't dispute that it was there to provide access and does provide access to get to the land. What we dispute is whether or not the intent of the easement when it was created in 1958 included getting to an additional house.
What was
Keeping
the
in mind,
ownership?
it's a 12-foot wide,
What was the ownership
dirt
of
driveway.
3B in 1958?
Excuse me, I didn't hear you.
What was the ownership of Lot 3B in 1958 after the easement was created?
In 1958, it was part of Lot B1. All the land involved here was derived from either B1 or B2.
And the mansion is what lot?
Excuse me.
The mansion on the top of the hill?
Is on B2.
B2. And B3 is part of B1 in 1958?
Yeah, 3B would have been part in 1958 of B1. I know it's confusing because the numbers keep changing, the designations keep changing. It took me a while to get it down, but yes. So there's no bright line
What your
issue
friend
here.
says is that when the easement was created in 1958, that it couldn't benefit Lot 3B because the mansion holders that were the dominant estate didn't have Lot 3B at that time.
Well, it actually, the easement, and it's in the record here, says it's for a driveway for B1 and B2. 3B is derived from B1. So no question that it's there to benefit, any part of B1 by way of a driveway. But the issue is a driveway to get to land or a driveway to provide access for construction vehicles, to build a house, and then vehicles to later associated with using the property for an additional house. That's the issue of overloading or overburdening that we have some difficulty with.
So your view is the easement was solely for the purpose of visiting a vacant lot and that was going to stay vacant forever?
No, it might not stay vacant forever.
But you can't build anything on it, right?
Actually, it said for the first 10 years, nothing can be built. There was a deed restriction when it was conveyed in 1968.
Right, but we're talking about 58. We're talking about the 58 easement. So in your view, the easement allowed you to get access to Lot 3B, but only to sit on the field and look at the trees, never to build anything on it.
In 58, yes, that was it. It was for access, because that's what was there in 1958, and that's what the parties were aware of in 1958. The case law requires the judge to go through an analysis of the zoning then, the zoning in 58, then in 68, the intent of the parties, answer the question of whether there were other avenues of access, keeping in mind that Lot B2 fronts on a very actively used public way. So that's our issue with the overburdening. Now,
Well, there's an issue as to whether this was even an issue at trial,
I didn't hear what you
correct?
said, Your Honor.
The overburdening issue, was it still a live issue at trial?
At trial, no, because it's decided on summary judgment. The defendants, appellees, moved for summary judgment on the issue. The judge, decided in their favor. My clients moved for a summary judgment, finding that there was an overburdening of the easement. That motion was denied. So that was all handled in the summary judgment proceeding and not at trial. So that issue is a live issue before the court.
Did the judge rule that it would not be overburdening, or did the judge just not address it?
Didn't address it, just said your motion is denied. So now, back to the relocation issue. What's very inconsistent about the appellee's position is the position they took on May 24, 2016, when the appellants were making renovations to the house and wondered whether or not the driveway needed to be reconfigured or relocated. This is the Servian estate, associated with those changes, and made a proposal, and this is all on the record, to the appellees to relocate the driveway, make it, change the grade, make it better, okay? And if you look at page 297 and 298 of the appellate record, there's a letter from the appellee's attorney saying, and I'll just read the last sentence of on the first page, it is their position, that's the appellee's, that the easement, which has worked well for parties for many years, remain in its present position. So that's their position in 2016. There were no incidents in the record, that would justify making any changes. There was no, incident where a fire truck couldn't get there or a public safety vehicle couldn't get there, where there were accidents.
What are they proposing? What are they proposing to do to the driveway, or what are they going to do to the driveway?
The appellees?
Yeah.
It's not entirely clear. We do have some, proposals in the record, but essentially they want to relocate it, make it significantly wider, and change the grade of it. But again, that's another issue. In the cases where there was vagueness in the location or dimensions of an easement that are cited, the court was put to the task, in the land court, of determining what is the location, what is the width of the easement, because it's vague from the documents. Here we claim it's not vague at all. The judge didn't say, okay, you can widen it from 12 feet, in this case, to 20 feet as proposed by the appellees, or you can, realign the curve so it's a different angle than it is right now. He essentially gave him a blank check, make changes to the width, make changes to the alignment.
Well, I don't think that's right. He said you can do all this stuff if it's reasonably necessary for the enjoyment of lot B squared, and so long as it does not unreasonably increase the burden of the driveway.
Yes, he did say that, but that really provides no objective standard, as in the cases where land court judges did, in fact, determine the width, determine the location. It's not an objective standard, and again, it allows the, so that means...
I wonder whether it's even really a judgment, because it seems to me that unless you all agree as to what is reasonably necessary and doesn't unreasonably increase the burden, which seems very unlikely, that there's no place to go but back into land court to litigate once there's an actual plan. Am I missing something?
Yes, unfortunately. Now, in the MPM case, we have guidance, clear guidance as to what needs to happen if it's the servient estate. But here, it's a dominant estate, and we don't have that guidance, and that's one of the problems.
And speaking of judgments, before your time runs out, I saw we just went yellow. On the interference, both you and your friend act as if the judgment is a finding of interference, but I don't see it in the judgment anywhere. Count 3 is just dismissed. There's nothing, I mean, I understand that there's dicta in the judge's findings about interference, but in the judgment, all I see is that you won on interference.
I'm looking at the judgment now. Well, he certainly in the decision, found that there was substantial interference, and even went as far as to say, my clients haven't interfered yet, with the 1968 easement, suggesting that they might do so in the future. But it's clearly in his findings, and we challenge those findings as unsubstantiated. The evidence, clearly shows that the moment the appellees raised the issue of safe passage of public safety vehicles, it was my client that called the fire department down to have the fire truck see if it could make it around the curve. Then my client, removed part of his stone wall to make it easier, okay? And then my client also moved some stones on the inside of the curve to make it easier. He also trimmed branches above it. The law is clear. The burden is on the servient.
And I get the feeling that whatever happens, your client wants fire trucks to be able to transverse
Yes.
the easement safely and
Yes.
properly.
Yes, and there was an incident, and again, it's in the record, while this case was pending, where there was an emergency at, the appellee's property, and a large fire apparatus, not the biggest one, drove up the driveway, around the curve with no problem, and drove out with no problem, with no impediment. So it's really not we think it's a red herring issue that they're using as a basis to justify widening and changing the location of the driveway, to enhance development. And in our view, it's based on an erroneous assumption that certain rules apply. The fire safety code, which it doesn't apply. The subdivision, regulations. There's no subdivision here. And the zoning bylaws.
I'm sorry, Mr. Alonso, I'm going to have to stop you there as you've gone over. Speaking of red, you're over time.
On past?
Yeah, it goes up.
Okay.
It starts after it goes to 0, then it starts counting up. So that's actually 1/7. You've had extra time.
I wasn't getting a little bit carried away, I guess.
Yeah.
Well, thank you for hearing me, and any argument that I haven't addressed orally, I rest on the brief. My belief.
Thank you.
Good morning. May it please the court, Bradley Croft for the appellees, the Bushnell Trust, and IQBAL and Samina Qadir.
Qadir.
Kind of hard to know where to start here in terms of the issues that are before the court. So I'm going to deviate from my outline and track what the appellants addressed. I'm going to start first with this issue of Lot 10E and Lot 3B. This is what I call a phantom argument because it's based on facts that simply do not exist. Lot 3B has always been and remains, although it's called Lot 10E today, part of the servient estate on the 1958 easement. When the 1958 easement was drawn, there were two properties. One was the servient estate in which Lot 3B was encompassed.
And just walk me through it. The servient estate included which lots?
B1. At the time of formation, it was B1 was the entirety of the servient.
Right, but walk me through what lots that was.
Yes, now, okay, so then in 1968, Lot B1 became Lot 3B and 3A. And Lot 3C was where the mansion is, which is at the end of the street.
And 3C was the dominant 1958 estate.
I believe I'm getting those correct, yes. I can tell you for certain that Lot 3B was still under common ownership with the servient estate. So to reach that lot, you didn't need an easement. It was a driveway that was owned by the people who owned that lot. The first time in recorded history that that lot ever needed an easement was when it was born in 1968, and it was separated from common ownership.
And when you say recorded, you mean, you don't mean like actually recorded, you just mean in...
Fair point.
Well, no, did I get
no,
that right?
no, I don't. Well, yes, I do, I suppose, because both with respect to recorded at the registry, but also in general terms, that lot didn't exist until 1968. And that brings us back to the four elements which must be met in order to find an implied easement. So all these answers are already done for us by the courts. Those four elements are, number one, that the lots in question had been under common ownership. Number two is that at some point in time, one of those lots was conveyed out from common ownership. Three is that that way in question was used in a similar fashion before and after that conveyance. And number four is that to enjoy the property, you have a reasonable necessity for that way. Those four elements were all proven in this case. So the notion, as argued here, that a 1958 easement, which had one purpose, which was to go to what's called 9 Bushnell, the big house at the end of the street, has always been its purpose. It remains its purpose today. That purpose was not impacted at all by the Lot 10E. So what the court did...
Okay, I'm just confused. So
Yes.
to get to 10E...
Yes.
If the house would be built there, you would still take the same driveway,
Correct.
and then when you get onto what was B2, it would be on the what's now over there. I mean, would
Right.
would it be extended through through the serving estate, or would it be part of the dominant estate?
So in 1968, when they came out from common ownership, that one lot in the middle, 3B, was landlocked. For the first time ever, it didn't have a right to access from the main road. So that's why the law says in that instance, there's an implied easement to get to that lot. The express easement, which has been there, never was meant to get to that lot. The easement, again, isn't a piece of property. Easement is a bundle of rights. That bundle of rights was enjoyed by one party and one party only, which was the house at the end of the street. That 1958 easement. Lot 3B didn't exist in 1958, and then when it finally came into being and was conveyed out from common ownership with the servient estate, then the party who owned it needed some legal access to reach it. That's why there's this implied easement. And this conflating of, well, they always had the right under the 1958 easement, they always benefited from the 1958 easement to reach that landlocked parcel, is completely wrong. That's simply not what the facts are. In fact, Lot 3B today, as we sit here, it's called Lot 10E, but it is still the servient estate to the 1958, because in order to reach that end of the street, you have to traverse over Lot 10E or Lot 3B. So it is, even in its deed, it's expressly subject to the 1958 deed. Easement, sorry. Other points here, if we get to the relocation, again, this simply was never part of the case. The idea, part of the trial, I should say, it was never requested at trial that this easement be relocated to a certain place. There was concern.
So if that's true, isn't the judgment wrong to declare it can be relocated?
No.
If you didn't request that?
The judgment didn't declare. If you read the judgment, it doesn't say it can be relocated. It simply says that as Your Honor correctly pointed out, said that it enjoys in its deed, the 1958 easement has a right to...
That you can realign that driveway?
Correct.
That's not relocate?
Not the way that we are envisioning it. It's redoing the contours of the driveway. It's not like an MPM where they picked it up and wanted to put it in some other place. But that was not part of our trial.
I'm seriously having trouble understanding the difference between relocating something and moving its contours. Those seem like the same thing.
To widen it, there's a hairpin turn in the idea of realigning it to move the contours of that hairpin turn so there's less severe of a turn so that these fire trucks can actually access this house at the end. That would be what we're viewing as realigning. But we never, again, Judge Vey never said that there is a unilateral right to do anything. So even if he had said there's a right to relocate, he's correctly said that it simply is, there's still guardrails here. You have to show, the dominant estate must show that it's reasonably necessary to do so. And number two, so long as such improvements do not unreasonably increase the burden of the driveway on the plaintiff.
But is that right? He doesn't actually cite any case that says you can move, the dominant estate can move an easement.
Right, he does not, there is, I'm not familiar with the case that says that a dominant estate unilaterally can move an easement. That's not what we're looking to do.
Well, forget
ultimately.
unilaterally. I couldn't find anything that said a dominant estate could move an easement without the agreement of the serving estate at all.
Correct, and neither did the judge. The judge said, so long as such improvements do not unreasonably increase. He didn't find here
Sure,
that
but
there's...
if the real law is that you can't move the contours of an easement without the agreement of the servient estate, then this, that you have the right to do it as long as it's reasonably necessary and doesn't unreasonably burden, is wrong.
That you do not have the unilateral right, that is a correct statement of the law. A dominant estate does not have a unilateral right to move the easement. We were seeking a declaratory judgment in terms of what are our rights to maintain this driveway. And that's where the judge focused. He said, in your deed, as a 1958 easement holder, you have not only a right to use it, but to maintain it. And our courts in this Commonwealth have construed that right liberally. And they have said that includes the right to realign. That includes the right to
Okay, so what case says that the right to maintain includes the right to realign? Because I didn't see.
The examples that are in the decision are on page 11, where there is, for example, the placement of gravel, there's paving. The widening is, again, throughout our brief, there are cases which stand for that proposition that parties may widen an easement. But again, what the judge said here, for example, the SJC in Cater versus Bednarek said that you should leave the requirements for the width to the town regulators. And if the town regulators say what it can be, and if somehow that's not satisfactory to the parties, they can come back to court at that time.
Well, Cater says where the instrument creating the easement does not specify its dimensions,
Correct.
a judge must establish the dimensions. But here it seems like the easement does specify the dimensions.
No, it doesn't. It simply says there's to be coextensive with the existing driveway. This is...
Well, isn't that a specification of the dimensions?
No, a specification of dimensions would be 12 feet, 14 feet, 18 feet, and no more. And even in cases where it does specify that, so let's say the deed said you have an 18-foot wide easement, as long as there's no language within the deed that restricts that or limits that, then a party is free to go back and make these improvements.
What case says that if it's specified an 18 wide or specified width, that a party can increase the width? Because again, I didn't see that. I didn't see a case that said that.
I believe Sarah Suolo says that. Let's see.
That one I didn't read.
Glenn versus Poole, I believe, says that.
Well, Glenn says you can flare the corners of an entrance. I don't really know what that means.
So Zygala versus Pike, Gale versus Manchester Essex Conservation Trust. We reviewed a number of these in our brief.
Okay, so Gale, that's the land court decision. What else did you have?
Zygala versus Pike, which is also a land court decision.
And you said something about Sorella?
Sarah Suolo.
Sarah Swell. I don't see that in your...
It's Bedford, I believe, Bedford versus Sarah Suolo.
Oh.
It's cited in the papers. These are all on
Yeah, okay, now I see it.
This is in page, starting on page 35 of our brief, when yes, so Zagala versus Pike, Belrose versus Old Tuck Cranberry Corp., and cases listed therein, Cater versus Bednarik, Glenn versus Poole, and Town of Bedford versus Saraswolo. So this, again, the notion that this judge, that should be overturned simply because he said you have a unilateral right of relocation. In fact, that was never actually said here by this judge, nor were we seeking it. He used judicial restraint, said, I'm not going to get to that point. All I am going to do is confirm, which we hadn't had confirmed by our neighbor until that point, that we actually did have rights as the dominant estate to ensure that an emergency vehicle could gain safe and swift access to this home. And the judge did make those findings. There's an argument that was raised about the location of the easement and whether or not they could, the 1968 easement could share the same property and same location as the 1958 express easement. And here, it's a finding of fact for the court to make. Here, the judge visited the site, he reviewed the plans and deeds, he heard the testimony, and he made a decision, found a fact that it corresponds with the existing driveway. There's no case law in Massachusetts to suggest that one easement cannot share geography with another easement.
Can I ask, you argue in your brief that the plaintiffs never raised overburdening and therefore there's no, so is overburdening, I mean, is that an issue that's yet to be determined?
No. In fact, on the 1960s, so the judge at the summary judgment decision, and it's well recorded, allowed our motion for summary judgment and stated in his decision on the record immediately after it was heard and said, I am not ruling on overburdening. We will have a trial on whether or not the 1968 easement was burdened. So that was never a part of the summary judgment decision. At trial, we showed that, in fact, the 1968 easement had not been overburdened because the purpose of that easement had never changed. It was always to reach a single-family house, as evidenced by the water and sewer, as evidenced by the 10-year restriction saying after 10 years you can have a house there, and testimony at trial where plaintiff said the original grantee told him, I intended when I did this, created Lot 3B, to build a house there. So in the cross motion for summary judgment, it was raised, but that was denied. And that issue is not subject to appeal under the deerskin trading case. You can't appeal the denial of a cross motion. I see my time is up. Thank you, Your Honors.
Thank you. The case is submitted. Thank you both very much. Interesting case. So what was the first case on for today? Wells Fargo Bank versus Jason Sutton, 22P516. And I take it you're not Mr. Sutton?
No, Your Honor. My name is Sean Higgins. May it please the court. I represent Wells Fargo Bank.
So let me just state for the record. So the defendant appellant is Jason Sutton, and he's self-represented, and he's not here today. I just want to state for the record that he filed his brief electronically, and he opted into electronic notice and provided us with an email address on March 15th, 2023. The clerk's office sent out notice of this argument, that we'd hear this case in May, and asked for the parties' availability. Wells Fargo responded, Mr. Sutton did not. On April 3rd, 2023, we sent out notice that oral argument would be held today. Again, you responded, Mr. Sutton did not. And our clerk's office has made several attempts to contact him, both by email and by leaving voice messages, including as late as yesterday, the clerk's office telephoned him and to remind him that there was argument today. Mr. Sutton isn't here today, so we'll just hear from the bank.
Thank you, Your Honor. Again, may it please the Court, Sean Higgins on behalf of Wells Fargo Bank, the appellee. If I may, Your Honor, just perhaps to add to Your Honor's comments, I would like to inform the Court I attempted to contact Mr. Sutton. In fact, from the courthouse this morning, I left him a voicemail and sent him an email. I emailed him earlier this week to confirm that we would be here to present our argument, and I have not heard a response. I would like to also confirm to the Court that Mr. Sutton is subject to a use and occupancy order in the trial court, and he has made his monthly payments every month. We receive a check from him, so we know he is still in the property and maintaining it because of the checks that we receive. But our efforts to otherwise communicate with him, including settlement communications we've attempted to have in the last few months, have gone without a response. So with that, I appreciate the Court's indulgence. I'm happy to answer any questions that the panel has. Short of that, I think I could leave it to the briefs if the Court would be inclined to take it on the papers.
I have a few questions. I just want to, but just give me a second. I'm jotting down what you said.
Certainly, I'm happy to repeat any of that, Your Honor. I'm sorry if I went too fast.
So the only real questions I have is I want to get an understanding of the trial exhibits, because there was some mention in the February 2020 argument about, we've got that transcribed call, but how there was an earlier part where there was a quote for the payoff. And I'm wondering whether the audio recording that's Exhibit 10, is there more to it than what's transcribed? Or is that transcription the entirety of what was given to the Court as Exhibit 10?
The transcript that has been submitted to this Court is a complete transcription of the audio CD that we provided to the trial court as an exhibit.
Okay.
Procedurally, Your Honor, this case had essentially what were 2 days of trial after there was a summary judgment ruling on almost all of the case. The original plaintiff in the eviction case was the Secretary of Veterans Affairs. That brought the eviction case to take possession after the completed foreclosure sale. Mr. Sutton was the defendant. There was a motion for summary judgment by the Secretary in which Judge Fine found almost all of the elements for the plaintiff's case for possession, citing to the completed foreclosure and the Gabriel case and the Hendricks case in Massachusetts that's prima facie evidence of a properly conducted foreclosure. The question that Judge Fine had was more about this loss mitigation effort and Mr. Sutton's response to defense, about noncompliance allegedly with the regulations. The Court then held a first trial at which Wells Fargo presented a witness who testified about the servicing of the mortgage loan. At that time, the Secretary of the Veterans Administration was the plaintiff in the case. After that hearing, Judge Fine entered a further order, and this is outlined in our papers, where she said, I need to have some more evidence about the November call. I really want to find out what happened that day. At the time, the Veterans Administration essentially, Wells Fargo repurchased the loan from the VA and substituted in as the plaintiff. That's when my office appeared. And in anticipation of that further trial date, what we did was we went to court with the stipulation, which is in the record again, I think that's in the impounded section, where we said to the Court, Your Honor, we recognize your request for evidence about the November 30th call. We have the best evidence of the November 30th call. We have it on audio. We also stipulated to the presumptive admissibility of certain business records from Wells Fargo. Those are also part of the impounded record before the Court. And what you'll find there, Judge, would be Wells Fargo's letter logs, which confirm the correspondence that was sent, account notes, which document and confirm the phone calls that were made to Mr. Sutton after the November 30, 2017 call. That letter log also provides confirmation that a reinstatement letter was generated and sent to Mr. Sutton.
Right, and we have the reinstatement letter too, right?
There's a copy of it in the record, Judge, that doesn't have the official letterhead. It's the internally generated version that Wells Fargo would have provided to Mr. Sutton by mail. And we then also have the audio recording where the payoff amount is provided to him.
So it looks to me like the record that you've provided has all the exhibits from the second day of trial, Exhibits 6, 7, 8, 9, and the transcript of 10. But what I couldn't find, I think I found Exhibit 1, the loss mitigation notes from the first day of trial, but I couldn't find Exhibits 2, 3, 4, 5, 2 emails, a letter, and 2 letters.
Those have not been submitted in the impounded record, and they were not submitted by Mr. Sutton or by us on the non-impounded record because the appeal issue that Mr. Sutton raised was the court's determination about compliance with the HUD regulation based upon the November 30th call only.
Well, it would be really helpful to me if you could, notwithstanding that, put together those first day exhibits and submit them as a supplemental appendix.
Absolutely, Your Honor. We'll provide the court with every document that we can from the first day of trial. Just to be clear, that first day of trial, there were exhibits that were marked and admitted in evidence.
Yes.
Okay.
Because you've given us all the exhibits from the day that you were there.
Yes.
Which I appreciate, but it'd be really, really helpful just to have all the exhibits for the first day as well.
And Your Honor, I will say, I can double check when I say that they're not in here. I don't want to say that with complete confidence. In preparation for today, where the issue I anticipated would be the second day and the audio, I would be remiss if I didn't say it's possible that they're in here somewhere, but if you've reviewed it and can't find it, then that's probably the case.
I could only find what I thought was Exhibit 1, but if you find them, just tell me where they are. That's just as good, but
Either way, we'd be
one way or
happy.
another, I'd like to have them or know where they are.
And just to be clear, Judge, are there questions about what happened at the first day of trial that are based upon the record before the court I can answer?
I don't particularly have questions, but it's very helpful to have all the trial exhibits when
Understood.
you're trying to write up something.
Absolutely. The totality of what happened here was that Wells Fargo had presented its case over a series of days to Judge Fine to demonstrate the compliance with the regulation. And in the first trial date, Mr. Sutton testified about the call, about this November 30th call, and he provided a version of the call that indicated that he had been, he used the term steered away from reinstatement, had been steered into loss mitigation instead of the reinstatement. He talked about his confirming that he was ready, willing, and able to pay, and that he had the ability. I think because of that, Judge Fine correctly said, well, if that was really what was going on, I'd like to really find out what happened. And at that first day of trial, that had not been the focus of the case to that point. And so Judge Fine, had that further trial. Once we dug in and realized what was said on the call, and if you review the transcript of the closing arguments, right, the way that it proceeded was that Judge Fine had us in for the second and final day of trial, and at the conclusion of the evidence, which really amounted to my client's submission of the audio recording and then the stipulated exhibits, there was no testimony from a further witness for Wells Fargo. Mr. Sutton, I believe, took the stand briefly for some examination about his ability to have paid back in November. And then Judge Fine immediately asked us to present closing arguments on the entirety of the record that had been presented. And if you review that transcript, you will see that during the argument, there was essentially a discussion about the phone call, and I believe Judge Fine's remarks to counsel for the other party was, I have the call, I've listened to it, so you don't have to tell me about your version of it or a characterization of it. I'm going to make a finding based upon having heard what was said on the phone call. If I'm being argumentative, I think those comments were intended to explain to Mr. Sutton's counsel that, unfortunately, Mr. Sutton's memory or characterization was probably not what the court was going to accept, given what was actually said on the audio recording, which, as an aside, I didn't present the audio CD to the court. We put it in the form of a transcript. To the extent that there's a request from the court and that can be facilitated, we can also make the audio recording available if that's necessary to the court. But suffice it to say, what Judge Fine ultimately did was she made a finding of fact using that audio recording and the other documents that were submitted, and those findings, as we've argued in our brief, would be subject to clear error. And we think because of the record that was provided to Judge Fine, I don't know that it's possible to find clear error when the best possible evidence of the phone call was was provided. And then using those findings, what we think is that Judge Fine correctly interpreted the applicable regulation in this particular case to find that Wells Fargo had appropriately communicated with Mr. Sutton to try to assess his financial circumstances, learn about the reason for his default, confirm what he wanted to do with the property, and attempted to work with him in a way to try to avoid the foreclosure that ultimately occurred. So given that procedural history, the factual findings, and what we think is a straightforward and correct interpretation of the regulations, we believe that Judge Fine's final ruling and judgment in the bank's favor should be affirmed by this court.
Can I just ask, you mentioned at the outset that you've been receiving use and occupancy. Is there also a bond? Did he also post a bond in this matter?
No, Your Honor. We actually didn't seek a bond in the trial court. The way that we ended up doing it by stipulation. In fact, at the time, Mr. Sutton was represented by an attorney from Legal Services in Western Mass, Daniel Balls, with whom we've worked before. And so Mr. Balls and I were able to negotiate the terms of an acceptable amount, and we entered that as a stipulation. I think there may be one instance where Mr. Sutton's payment was perhaps late, but for the most part, he has been timely making those payments and remains current as we sit here today.
So what's the impediment of getting him back on a regular loan? And
a lot of this would be extra outside the record, Your Honor. I'm happy to answer questions. So the primary impediment for getting him back on a loan is that the mortgage has been foreclosed and extinguished by operation of law, and there is no longer a mortgage loan account available for the bank to modify. It has been extinguished. The mortgage has been converted into an ownership right, and Wells Fargo is the owner of the property by virtue of that foreclosure. With the court's indulgence, I'm happy to share, we have attempted to solicit from Mr. Sutton options to avoid the ultimate and final ending, which would be perhaps a constable-aided move-out, which obviously my client would like to avoid. In that way, we actually received from Mr. Sutton and a third party indication that he may have been able to obtain financing to make an offer to purchase. Part of my introductory remarks about trying to communicate with Mr. Sutton have included several emails in the last several months asking him if he has a written offer from my client to consider, and I have received, unfortunately, no response. So,
right. I appreciate your candor. Thank you, and I appreciate you waiting to be second today and being here. So, any other questions? I think we understand your argument, and we'll take the case as submitted.
Thank you very much, Your Honors.
Thank you, Attorney Higgins. And so that will conclude our session for today. I want to thank the court officers and the clerk's office, and we'll be in recess.